What are you fussing about? We prefer seeing your face, sir. You're muted. I can't hear you.
I don't see anything.
Hear ye, court will come to order this day, Mr. Richard Schmidt. Read radios.
Katie Wilson.
Hi, Ms. Wilson, how are you?
Well, how are you?
Been fine. Go ahead, Mr. Schmidt.
Judge, we've been working back and forth to try to resolve Ms. Wilson's case. This afternoon, I filed a motion seeking an evaluation and asked the court to review that and grant that before we move forward on her case.
Okay.
That's what you got.
And the court has reviewed the motion and the court will grant the request for an evaluation for Ms. Wilson.
Did you want to set this for a status or you want to just leave it open?
No, let's set it for status. That way I can make sure that she's seen by Dr. Heamer sooner rather than later. Let's set, how about September 26th? That's the last Tuesday of September.
That should be fine. Thank you.
All right, we'll set this also for on the evaluation September 26th at one.
So as soon as ready to do that. As soon as he's done, we're going to the next. Yeah, it's, thank you.
All right, Mr. Evans, are you ready?
Yes, Your Honor. My client's name is Chastity Smith.
All right, Ms. Smith, you come forward. CR 22-49, 7 pretrial.
Afternoon, Your Honor. Here's Ms. Smith. Your Honor, this is an older case, but it is, things have been transpiring in the last 18 months or so that prevented us from being able to move it forward. I'm going to ask the court to set us for a subsequent pretrial hearing. I haven't really touched this case in a while, and I need to get my feet back underneath me and have some conversations with the DA's office to see what we can't do about moving it forward and resolving it.
Yeah, I just realized. Let's see. Ms. Curry, are you there? I'm not seeing you. Mr. Hartwell. Is there any objection, state?
No objection, Your Honor.
Okay, all right, let's set Ms. Smith for an additional pretrial. What did I set you for this morning, Mr. Adams?
1024, Your Honor.
That's probably a little too long on this case. You agree?
I do.
All right, what about September 19th, 21st, or 26th?
Your Honor, I'm already here on it was, September 21st. Oh, there it is. So if you want to add this one to that one, that would be appreciated.
Court sets Ms. Smith for September 21st for pretrial.
Your Honor, that's all I have this afternoon with you, unless you have some surprises for me, but if not, may I be excused?
Yes, sir. I don't think that there's any surprises from my end.
Okay, good.
Thank you. Appreciate you being here.
Yes, sir.
Manning, who are you ready with?
Judge, we have Miss Ferguson here, CR 20-00289.
All right. Amy Elizabeth Ferguson, and are we going to plead today on Ms. Ferguson?
That's correct, Judge.
All right, I believe I have that papers here, Mr. Manning. So, all right, Ms. Ferguson, if you'll raise your right hand, I'm going to place you under oath. Ms. Ferguson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir. Your Honor.
All right, you can lower your hand. Ms. Ferguson, I have a few questions for you. Are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
Yes, sir.
Can you tell me about that?
I just had depression when I was younger.
Okay. Are you on any type of medication or on treatment for that disorder?
No, sir, not right now. No, I'm not.
Okay. Do you feel like you have a rational understanding of what's going on in your case?
I do. Thank you, sir. Yes, I do.
Good. And you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you?
Very much so.
All right. Understand everything that you've read and signed in the paperwork today.
Yes, sir. I understand.
Mr. Manning, do you believe Ms. Ferguson to be competent?
She is, Judge. I've had a conversation with both her today and previously, and she understands the charge against her, the nature of the charges, possible defenses, and she's been able to participate in the plea negotiation process.
Thank you, Mr. Manning. All right, Ms. Ferguson, you are charged by indictment with a second degree felony offense of possession of a controlled substance. Is there a reduction in this case, Mr. Manning?
Yes, Judge, they're abandoning, it was a punishment enhancement. They're abandoning that enhancement paragraph and proceeding under the state jail amount for the charge.
Okay, so Mr. Hartwell, I believe the judgment says, and Mr. Manning, look on yours, does it say second degree felony there?
It says the second degree there, but it says that enhancement was abandoned in the police section, and then in the enhancement paragraph section, it says it was abandoned as well there.
So y'all want that to say second degree felony? on offense for which defendant convicted. You'll want it to say the second degree felony.
Judge, when I noticed it, it looked a bit odd to me, but based on the language of it saying that it was reduced and abandoned on the enhancements, I think it would be sufficient, but I don't know what TDC would say.
Your Honor, if I may, I think to be on the safe side, it might be worth going ahead and redoing it and making sure that it does reflect state jail.
Yeah, I think that would probably be the better move to do as well. You know, if she were going to the institutional division, it may cause more of a concern than the state jail division because of the absence of parole at state jail. But I think to be more accurate, I would just ask the state to change the face of the judgment to reflect that the offense that was convicted, make the degree match up with the offense. If there's an abandonment of enhancement paragraphs to show that it is a state jail felony. All right, Ms. Ferguson, you are charged with a state jail felony offense, possession of controlled substance, penalty group 1, less than 1 gram, that does carry a range of punishment of not less than 6 months or more than 2 years in a state jail prison, and also a possible fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir, I do.
And I see that there is a plea agreement in your case in which it appears that you would plead guilty to that crime in exchange for the state's recommendation that your punishment be assessed at 7 months confinement in state jail with restitution of $180 plus court costs, reimbursement fees. And the state, as Mr. Manning has said, is agreeing to abandon the enhancement paragraphs in this indictment. Is that your understanding of the plea agreement? In addition, you would receive 101 days credit towards those 7 months, as you've already served 101 days, so you would receive credit for those days spent in jail. Is that your understanding of the plea and what you're asking the court to approve?
Please, yes, sir.
Okay. All right, then Ms. Ferguson, how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty, sir.
Are you pleading guilty to that crime, Ms. Ferguson, because you are in fact guilty of committing that crime?
Yes, sir, I am.
Has anyone threatened, forced, or pressured you to plead guilty?
No, no one.
The court does the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection, Judge.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
No defense.
Sorry, Judge, we're having a hard time hearing.
Anything further from the defense?
Nothing from the defense, Judge.
All right, we're going to review the stipulation of evidence. All right, court, having reviewed the evidence, finds that there is sufficient evidence to convict Ms. Ferguson of this offense, or will follow the plea agreement, or convicts her of possession of controlled substance, penalty group 1, less than 1 gram, assesses her punishment at 7 months confinement in the Texas Department of Criminal Justice State Jail Division, orders her to pay $180 restitution, $290 court costs, $85 in reimbursement fees, and the court awards her 101 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Ferguson, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over to be fingerprinted. Once you are released from prison, I want you to report to the courthouse so that you can make arrangements to discharge and pay your restitution, court costs, and reimbursements. Okay?
Yes, sir.
Thank
Thank you.
you.
Judge, I believe that concludes my business. May I be excused?
Let's see.
Thank you, Judge.
Hello, Mr. Head. How are you, sir?
Good, Your Honor. How are you?
Yeah, doing well, doing well. You're here with Jared Green, or I'm sorry, Jared Green Anderson, correct?
That's correct, Your Honor.
All right, this is cause number CR 18295. And so my understanding that Mr. Anderson will be pleading today.
Your Honor, it was my understanding we had an agreement. The DA's office, I think, didn't have the details of the agreement, so we don't have paperwork today. But I believe we have an agreement that we just, if we can announce that on the record and get whatever the quickest reset is, we'll get paperwork together and get that done.
Okay, yes, go ahead. Tom.
Yes. Judge, that's correct. We had extended an offer to Mr. Head and his client several weeks ago. We never heard anything back from Mr. Head. Today, he apparently called Miss Taberham and informed her, but of course, it's too late to do the plea papers today. If he will just kindly let us know when his client is willing to accept a plea offer, then we'll have the plea papers ready for him. But we have to know at least one day in advance.
I apologize, Your Honor. Mr. Weiner appeared last time, and I thought Mr. Weiner had communicated back with the DA's office. So if that was a miscommunication between me and Mr. Weiner and the DA's office, I apologize. But I think we can get another setting, you know, whenever the court can get us back in, we'll have the paperwork and have an agreement. There's some fees that have been paid by Mr. Anderson to our office, and we need to get those to the DA's office to square away some fees on this probation in order for the agreement to be done.
Those should be paid to probation, Judge.
Okay.
Great. Mr. Head, I could get you back in Thursday of this week, day after tomorrow. It's an evidentiary docket, but considering that Mr. Anderson's in jail, we could place him on that docket.
I think that would be fine. Would that be in the afternoon again?
Yes, sir. It'll be at 1:30.
Yes, sir. That'd be fine.
Okay. All right. We'll set Mr. Anderson then for plea on 8/24 at 1:30.
Yes, that's nature. Sure, here, yeah. Ms. Curry, do you need me to get with you on those exact details, or do you have those already for the paperwork?
I believe I have, I mean, the plea offer that was extended was for 9, I believe.
Well, it was not, if the fees were not paid, he has the ability to pay the fees, so it was for 6.
Okay, we'll get it ready.
Okay, and then we just need to know an exact total so I can get you a check, but I'll call your office.
Okay, great. Thank you.
Thank you. Thank you, Your Honor. May we be excused?
Yes, thank you, Mr. Head. Mr. Anderson, we'll see you on Thursday. Mr. White, are you ready?
Let's call Mr. Bailey.
All right, this is file number CR 23-96, State versus Kenneth Dale Bailing for pretrial.
Your Honor, we don't have anything additional file on pretrial at this time. We're gonna ask the court to move this over to docket call.
Okay. All right, court will set Mr. Bailing for docket call on September 21st. At 1:30.
Thank you, Your Honor.
So you're welcome. You ready on Mr. Green?
Yes, sir, I am.
All right, Holton Castle Green, CR 20-303. Show that Mr. Green has been placed back on the docket for after the discharge from the pretrial intervention program.
Yes, sir, that's correct. Your Honor, Mr. Green has got an additional charge in Kaufman County. My understanding is that Joseph Russell is handling that matter. I'm gonna get with Mr. Russell, see what they're kind of trying to do over in Kaufman County, and then Ms. Curry and I and Mr. Hartwell have discussed a possible resolution regarding this, but I want to make sure that we're not stepping on anybody's toes over there. And then I would anticipate or hope that if we could reset it for September 21st, that we'll have an agreement by that time.
Objection, state.
No objection, Your Honor.
All right, board sets Mr. Green for docket call hearing on September 21st. That'll be at 1:30. Mr. White, please let your client know that he resolves his cases in Kaufman and is released on bail here. Hearing will be at 9 a.m.
Yes, sir, I will. Your Honor, that's all I have.
Thank you, Mr. White.
Thank you.
Your Honor, Mr. Schmidt is going over plea paperwork. I'm gonna get Mr. Morello up here, the one that does not have an attorney. And be just a minute.
Yeah, it was awesome.
Your Honor. Okay, on CR 22-191, I believe on our docket, we have him as Morello.
Yes.
They have him as Baroness out here, but
Very
He-
interesting.
yes, he speaks very little English. He is telling Deputy Fabio that
Whatever he had was seized in the arrest in Dallas.
whatever property he had that he had shown on his affidavit has been seized by Dallas County.
Okay.
And so we will need him, I mean, I guess I'll need to give him a court-appointed attorney and then reset him with an interpreter.
Did he fill out the affidavit of indigency?
Yes, sir.
And then based on that, did he meet the criteria? We're gonna question him about that.
No, he did not meet, we had no financial need, but in speaking to him now, the property that he owned has been seized.
Go ahead and appoint, and then you can always have an indigency hearing at a later time.
Okay, and then we will need to reset him for me to get an interpreter.
Correct.
Okay.
So let's just go ahead and reset him now. You don't have to bring him up, I'm just saying on the record. On cause number CR 22-191, we'll reset Mr. Jaime Rodrigo Barrientos to September 19th. For arraignment. Appoint counsel. And that'll give council time to go over the indictment. Meet with them.
Okay. Okay, and then Mr. Schmidt is ready.
All right, Mr. Schmidt, who do you want first?
Darrell Dugan.
All right, Darrell Dugan, CR 16-473, motion to revoke. Go ahead, Mr. Schmidt.
That's correct, Judge. Mr. Dugan was recently extradited from Louisiana to our facility. I met with him for the first time on Monday. We're not quite ready to proceed, but I've begun negotiations with Ms. Curry who'd asked this matter to be reset on a regular docket next month.
All right, court will set Mr. Dugan for hearing on the motion to revoke on Tuesday, September 19th. We'll also setting for the evidentiary hearing. That way, if there is no resolution on the 19th, we'll go ahead and set him for contested hearing on the 28th.
James Calixto.
James Lopez Calixto, CR 19-10. Motion for revoke. Go ahead, Mr. Schmidt.
It is, Judge. I have a same announcement, Mr. Calixto. I just recently received an appointment from the court on the motion to revoke. I have a prior relationship with Mr. Calixto, so I anticipate meeting with him on Monday to ask that the motion to revoke be set on that September 19th date, and I guess the 28th is the other one.
Yes, sir. All right, court will set Mr. Calixto's motion to revoke for hearing on September 19th and on the contested docket on September 28th. If there is no resolution.
This is Billy Joe Schultz.
All right, cause number CR 21-243, motion to revoke. Go ahead, Mr. Schmidt.
Judge, I think we're fairly close to a resolution for those two, on Mr. Schultz as well.
All right, court will set Mr. Schultz for hearing on September 21st. If there's no resolution, contested hearing on September 28th.
Did you say the 21st or the 19th on that?
I'm sorry, I did say the 21st. I meant to say 19th.
This is Joseph Holloway.
Joseph Garrett Holloway, CR 14-16. Go ahead, Mr. Schmidt.
So this is we're into a motion to revoke.
Say that again.
We're prepared to enter a plea to the state's motion to revoke.
All right, I don't believe I have any paperwork here. Can you tell me what the terms are?
Can Judge, upon a plea true, the state's recommending the court that Mr. Holloway's supervision be revoked. Sentenced to 3 years confinement in TCJ institutional division in order to pay the balance of his financial obligations, which appear to be $3,000 in fines, $518.39 in court costs. And in addition to that, he has 196 days credit towards that sentence.
Thank you, sir. All right, Mr. Holloway, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your. All right, give me just 1 second. I want to pull up your motion to revoke so I can review it. All right, Mr. Holloway, it appears that you were before the court on May 12th, 2022, and you pled guilty to the offense of burglary of a habitation. By way of plea agreement, your punishment was assessed at 7 years confinement in the Texas Department of Criminal Justice Institutional Division. However, on that day, the court followed the plea agreement and suspended that 7-year sentence and $3,000 fine and placed you on community supervision for a period of 5 years. And it was during that term of community supervision that the state filed this motion to revoke on June 13th of 2023. And in this motion, as you can see, as I'm demonstrating here on the screen, there appears to be 8 counts of various violations. Have you had enough time to review this with your attorney, Mr. Schmidt?
Yes.
And do you feel like you've had all of your legal questions answered and you're happy with the legal representation that he's given you?
Yes.
Is there any questions that you have for Mr. Schmidt with the court before we go forward?
No.
All right, Mr. Schmidt, you've explained to Mr. Holloway his rights as they pertain to this motion to revoke.
I have, Judge.
You believe that he is competent, and if so, that he is entering into this agreement intentionally, knowingly, and voluntarily.
Yes, sir.
Does your client intend to play true to all 8 counts?
He does, Judge.
Mr. Holloway, then, at this time, I would ask you, how do you plead to counts 1 through 8 as contained in this motion? Are those counts true or not true?
True.
You're telling me that all 8 counts are true because in fact, you have committed the violations as alleged. You're not just saying that they're true so that you can get a reduced sentence. Is that correct?
True. Yes, sir.
Okay. All right. Or will accept the defendant's plea of true to each count alleged in the motion. Mr. Schmidt, is there any objection to the admission of the defendant's waiver of rights to plea of true and evidence?
No objection.
That is admitted and the court takes judicial notice of the defendant's judicial conviction. Is there anything further from the state?
No, Your Honor.
Anything further from the defense, Mr. Schmidt?
Nothing further, Judge.
All right, then based on the evidence before the court finds that Joseph Garrett Holloway has violated the terms and conditions of his community supervision court will follow the plea agreement in this case. Based on those violations, the court will, upon the finding of true, hereby revoke Mr. Holloway's community supervision, assess his sentence at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and awards him 196 days credit for the time that he has spent in jail on this cause. Mr. Holloway, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over to the deputy.
Judge, I need about 10 minutes or less.
Yes, sir.
Your
Yes. Yeah, go ahead.
You want to go ahead with the extradition while we're waiting, or
Yes, yes, we can do that. Do I have that paperwork in here? It's on your desk.
you're what?
The extradition paperwork, do I have it or is it on your desk?
I have,
Do I have it?
I have it.
Right, do I have it also? So I can make that.
I'll send it to you. Just a second.
You want me to run it? Real quick?
Okay.
I'll send it to Wayne.
Your Honor.
Yes, ma'am.
Okay, we're ready when you are.
Okay, all these.
Y'all showed you any of this paperwork. Okay. If you want to start reading this, the judge is going to go over this with you. This is about the formal extradition. So if you'll read these while we're.
All right, is your last name pronounced Michelle?
Yes, sir.
Michelle, okay. All right, are you Jeremy Scott, Michelle?
Yes, sir.
All right, Mr. Scott, as Ms. Abraham has told you, the hearing today is extradition hearing. And so it appears that you have your person body has been requested by the state of Louisiana, specifically Caddo Parish. They are indicating that you are wanted for a felony charge of possession of a Schedule 4 controlled substance in that state. And they've indicated that they want to extradite you back to their state for you to face those charges. So the purpose of our hearing today is for me to advise you of your rights regarding extradition. And so just generally speaking, because you are what is known as a fugitive from justice, and meaning that you are wanted in some other jurisdiction, in this case, another state, the state of Louisiana. Now that you are confined in the state of Texas, the state of Louisiana can't just merely show up here at the sheriff's office in our county and ask for you to be turned over to their custody. There's only two ways that can happen. One way is that they request that you be formally extradited back to their state, means that they ask for authority to do so. The way they ask for that authority is the state of Louisiana would, through their governor's office, communicate to the state of Texas and its governor's office. And they would ask the trial officials in that Louisiana, it would be the judge over there, possibly the DA. And here it would be, my court or the DA's office. And what would both entities would be doing is trying to figure out if you are the same individual, Jeremy Scott Michelle, that is in fact wanted in Louisiana. If it's determined that you are one and the same and that the legal documents are sufficient, meaning that they are properly executed for extradition, that they are charging you with felony offense, once your identity is fixed, then you could be legally returned by the authority. The state of Texas will grant authority for you to be returned to Louisiana to face the charge of possession of Schedule for controlled substance, okay? In that process, if you choose to be formally extradited, you are entitled to have an attorney appointed to you. If you are indigent, you cannot afford one. And I provided some information there on the form that's called admonishments. It's called formal extradition there. And it tells you that the issues of guilt, innocence, criminal responsibility, any of those fact issues regarding possession of Schedule 4 in Louisiana are not the issues that would be here. The attorney, if you were appointed one, that would be representing you here, they would determine whether or not you are the same person that's being requested, whether or not the supporting documents are in order, and there's whether they charge you with a crime that requires extradition, and whether or not you are a fugitive. So the issues that would be in the extradition hearing are limited to those, okay? And so you would be entitled to appointment of an attorney, and we would have a hearing to determine whether or not the extradition process is being properly followed between the state of Louisiana and the state of Texas. That's one way for Louisiana to take you back to their jurisdiction. The other way is, once you understand your rights of extradition, you decide you want to waive all of those formalities and you consent to the state of Louisiana taking you back to face charges on the possession of Schedule 4. So basically that would be you consenting and saying that you understand what your rights are. You understand that you have the right to be extradited, right to an attorney appointed to you if you can't afford one. And understanding all of those rights, you say, I'm going to waive all of those rights and I'll voluntarily go back to Louisiana. Usually the question I get from individuals such as yourself is, how long does each process take? I don't know if you are interested in that, but formal extradition obviously takes a little bit longer because you have two governments that are having to execute legal documents and communicate those, review those, set those hearings. All right. So that could take more than 30 days. All right. And if you waive extradition, then what we would do here is we would notify Louisiana that you are ready for pickup, and they typically 7 to 10 days, maybe 14 days, they would be here to pick you up and return you. It could be up to as long as 30 days. If for some reason you waive extradition, but you are sitting in jail for longer than 30 days, I could at that time conduct a hearing and determine whether or not you should be released on bail pending them coming to pick you up. Okay. So do you understand? You understand extradition and the way I've explained it to you?
Yes, sir.
All right. You have any questions about any of that?
No, sir.
Okay. All right. So today you have to make a decision on what you want to do. Do you want to be formally extradited, or do you want to waive formal extradition?
If I understand it, to the right, if I waive my rights, it'd be a little faster to get over there.
In my experience, typically, yes, because you are made available immediately, and most jurisdictions act with diligence to get people picked up sooner rather than later. Formal extradition does extend the period just because legal documents then have to be drafted, filed between two state governments, and that usually slows down the process.
Yeah, that's one of as complicated as possible. So yeah, let's go ahead and waive my rights.
Okay, and you understand what you're waiving. You're not admitting guilt or anything of that nature. You're just waiving the right to be formally extradited by a legal process.
Right.
Okay, if that's what you want to do, Mr. Michelle, then you'll just sign there on the waiver of formal extradition. Mr. Abraham will bring that back to me later. I will sign my portion. And we'll send that to Caddo Parish today and let them know you're available for pickup. And they could be here within the next couple of days.
Okay.
But in any event, if you're not gone within 30 days, the jail there will notify me and we'll conduct a hearing, and I may release you on bail if they haven't picked you up within 30 days. Okay.
All right, thank you.
You're welcome, sir. Have a good day.
Okay, we need about 5 minutes.
Yes, ma'am.
Your Honor.
Yes, ma'am.
So we're ready, finished.
Oh, let's see. All right, Mr. Schmidt, are you ready?
Warren Pruitt, Judge.
All right, is Mr. Pruitt a plea as well?
Judge, we were going to plead, and we have some issues with probation. So we're gonna have to reset him briefly and come back and hopefully get him knocked out within the next week or two.
Only phone items I have are Thursday or September 19th will be the next release.
Let's do September 19th, if that's okay.
That's fine. Right, court says Mr. Pruitt, September 19th. One.
You can leave it just as you can, but you know. Yeah, just go sit down. Fine.
Who's next?
Michael Bowman. CR 23.
This is. All right, cause number CR 23-5, versus Michael Bowman. Go ahead, Mr. Schmidt.
Judge, this will be the plea. Do you have the terms or do you
I think I do.
prepared to proceed?
All right, show me the raise your right hand. Sir, do you swear, raise your right hand. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Your name is Michael Dwayne Bowman, is that correct?
Yes, sir.
And Mr. Bowman, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the representation he's given you?
Yes, sir.
Do you have any questions for him or the court before we go further?
No, sir.
I see that there's a plea agreement in your case, in which you are charged with a third-degree felony offense of evading arrest or detention with a vehicle. A third-degree felony carries a range of punishment not less than 2 years or more than 10 years in prison and a fine not to exceed $10,000. Plea agreement appears to be that you would plead guilty to that crime. State's recommendation is 6 years confinement in prison plus court costs and reimbursement fees. You would receive 57 days credit towards that sentence for time you've already been in jail, and the DA's office would be dismissing a possession of marijuana less than 2 ounces. Mr. Bowman, is that your understanding of the agreement?
Yes, sir.
Mr. Schmidt, do you believe Mr. Bowman to be confident?
I do.
And you explained to him his rights and believe that he is entering into this agreement intentionally, knowingly, and voluntarily?
Yes.
All right, Mr. Bowman, then, how do you plead to evading arrest or detention with a vehicle?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are in fact guilty of that crime for no other reason?
Yes, sir.
Has anyone threatened to force you to plead guilty today?
Yes, sir. No, sir.
All right, court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objections to the stipulation of evidence?
Okay.
All right, stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
No, sir.
All right. Let's go review the evidence.
And Judge, for the court's information, The stipulation of evidence provided by the state has been signed by both myself and Mr. Bowman after review.
Thank you, Mr. Schmidt. All right, the court has reviewed the evidence, finds that there is sufficient evidence to convict Mr. Bowman of this offense. The court does follow the plea agreement today. The court convicts Michael Dwayne Bowman of evading arrest for detention of the vehicle, a third-degree felony. Assesses his punishment at 6 years confinement in the Texas Department of Criminal Justice. The court orders him to pay court costs of $290, reimbursement fees of $85. The court dismisses under section 1245 DA 2022-1146, possession of marijuana less than 2 ounces. And the court awards Mr. Bowman 57 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Bowman, you're hereby remanded to the custody of the sheriffs. We carry out the terms and conditions of this. Please step over to the deputy to be here.
Well, you'll make copies and bring it to us. Yeah, he'll give you a couple of-
Mr. Trent, did you notice, Mr. Harwell, I don't know if you did either, but I just noticed the stipulation of evidence, it's showing up in the second page of the judgment. Did you notice that? Mr. Schmidt,
Didn't notice that,
do you have a judgment there with you?
yes.
See, that was just an error on this one. I haven't noticed that one.
Yeah, I saw it. And ultimately, it appears to be in the block for community supervision, and it's not checked, and so I skipped past it, but yeah, I'm not sure that that's I don't know if the OCA wants that in there.
Yeah, we may need to fix it. I've just grabbed another, this one's order for education. A little bit different though, but I see like a block for fines right here.
Yeah. This one is Mr. Coleman's, and it's right by the division order, right above the files.
Okay, so Mr. Hartwell, if you could have this avenues in your office, correct Mr. Bowman's judgment. So what I'm talking about is right above the fine. There's the stipulation of evidence got copied and pasted in here in the midst of some community supervision language. Just because he is going to TDC, I don't think that would cause a problem, but I'd rather err on the side of caution. So if we can just get a new second page and have that information deleted out of there.
Yes, Your Honor, we'll work on that. Thank you.
Thank you.
Judge, apparently we also have discovered the same issue on Mr. Manning's client, Amy Ferguson, who is a TDC plea that was done earlier. And apparently that has the same language in the judgment. The same.
Okay, so Mr. Hartwell, if you'll make a note of that as well on Ms. Ferguson. I didn't have her physical judgment earlier, but they have it at the jail. So Ms. Ferguson's second page appears to be wrong as well.
Yes, Your Honor, we'll take a look at all the ones from today just to be double sure.
Okay. All right, Mr. Green, do you have any? I'm sorry, Mr. Schmidt, do you have any?
This is Jacob Wyatt Myers, R 2330.
All right, Mr. Myers, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your. All right, and this is a plea today. Appears to be on a deferred for 5 years on the charge of third-degree assault, family house. Right.
That's correct, sir.
All right, Mr. Myers, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
You're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the representation he's given you?
Yes, sir.
You have any questions for him or the court before we go further?
No, sir.
You understand everything that you've read and signed today?
Yes, sir.
All right, Mr. Schmidt, do you believe Mr. Myers to be competent?
I do.
Do you believe that he is entering into this agreement intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Mr. Myers, you are charged by indictment with a third-degree felony offense, assault on a family or household member with previous conviction. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years confinement in prison and carries a possible fine not to exceed $10,000. The agreement in this case appears to be that you would plead guilty to that crime. The state in turn would be recommending to the court that the court review the evidence, but not convict you of the offense, but rather place you on deferred community supervision for a period of 5 years, along with a $1,500 fine, court costs, and reimbursement fees of $535. Mr. Myers, is that your understanding of the plea agreement?
Yes, sir.
Understanding the range of punishments. Let me also talk to you about this real quick, Mr. Myers. Do you understand that if I approve the plea agreement today and I place you on probation, if during this 5 years that you're on probation, if you violate any of the terms of your probation, the state of Texas, through its attorneys, could file a motion to adjudicate your guilt. That means motion to convict you. They could ask this court to conduct a hearing. And if the court during that hearing determines based on the evidence that you violated any of the terms and conditions of your community supervision, the court could do a number of things, including convicting you of the offense, revoking you off of community supervision, and sentencing you to prison anywhere from that minimum of 2 years all the way up to the maximum of 10 years. Do you understand that?
Yes, sir.
So that's a risk, and that's a risk that you're willing to accept. Is that correct?
Yes, sir.
All right. So understanding the range of punishment, court finds that I've admonished Mr. Myers on the inherent risk with deferred adjudication. On the other side of that, Mr. Myers, if you successfully complete your community supervision without violations, then the court can dismiss your case and you will be discharged from that community supervision without a conviction. You understand that?
Yes, sir.
All right, understanding all of those things, Mr. Myers, at this time I would ask you, how do you plead to assault of a family or household member with a previous conviction?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone forced, threatened, or pressured you to plead guilty to this crime?
No, sir.
Court accepts the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
That's submitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Mr. Harlow, is there any concern of the victim for probation plea or any other issue that you're aware of?
None that I'm aware of, Your Honor, although I can double check if you'd like.
I'd just like to know if the victim is supportive or if they're not supportive of the agreement. While he's doing that, Mr. Schmidt, anything further from the defense?
No, sir.
And Your Honor, I show that the victim impact statement was sent out, but was not returned. So state is in compliance. But we do not have a return victim impact statement.
Thank you, Mr. Rose. All right, then. Review the evidence. All right, the court, having reviewed the evidence, finds that there is sufficient evidence to convict Mr. Myers of this offense. The court will follow the agreement today. The court defers the finding of guilt on the third-degree felony offense charge of assault on a family or household member with previous conviction. The court places Mr. Myers on 5 years community supervision, orders him to pay a $1,500 fine, $290 court cost, $535 reimbursement fees. Mr. Myers, you hereby remanded to the custody of the Community Supervision Corrections Department so they can carry out the terms and conditions of the sentence. We will go over and get fingerprinted with the deputy, and then the probation officers will give you more information about what to do when you get out of jail.
Yes, sir.
All right, you're excused.
Thanks, who?
We need to talk about Mr. Gonzalez, the first county, took care of this morning. And all these things. And we've been talking to them.
I'm pressure. Stop that, but. Okay.
Your Honor, I believe we have 2 more on the docket.
Mr. Juan Gonzalez and Ryan, Augustine.
Yes.
And Mr. Gonzalez, we were going to enter a plea with him today, but apparently he got pulled for what county?
Rusk County picked him up this morning.
On
Yeah.
a bench.
Yes, sir. I presume it was a bench one.
Oh, it was a bench one. Okay. Okay, all right, so let's reset Mr. Gonzalez, we'll do lead status on his whereabouts, I guess. You want to do that September 19th, Mr. Smith?
Sure, yeah.
All right, and what about Mr. Augustine?
Last time, yeah, he's still, yeah, I don't.
I mean, I was waiting to see if y'all wanted us to bench.
Okay, we'll probably need to bench warrant him, but I'll talk to Miss Curry and I'll get with Miss Patty and we can set him for that 19th date. If I can convince the state to seesaw activity in Van Zandt County, then that would be great, but if not, then I'll let Miss Tabraham know to bench him from TDC.
Mr. Augustine, one, did you represent him previously?
Judge, I was retained on the assault case. And the secondary case, and I have never spoken to him about that case. He picked that up while we were waiting to resolve the first one. He did not retain me on that, and I haven't spoken to him about it, but I was hoping, you know, to get a one-stop shop for him as soon as I saw him, but I haven't seen him for quite some time. He's been in custody in Dallas and then now TC.
Okay, well, and depending on what you and the state discuss, I guess we could always inquire with CDC about a Zoom appearance for purposes of arraignment as well. If we,
Yes, sir. I know that on the assault case, he has been arraigned. The new case, I'm sure he has never been arraigned, at least not in my presence. So we were at the stage of the previous case when he was taken into custody in Dallas and has been there ever since. And I think it's got to be at least over a year.
all right, so let's set him for that 9/19 date. And then if you and the state decide you don't need him, just let Ms. Tabraham know as soon as possible. Ms. Tabraham, how much time do you need to give the sheriff? I know as much as possible, but let's kind of 2 weeks notice at least.
Depending on where he's at, you know, how far he is from our location. Yeah, 7 to 10 days is what they request.
Okay, so that'll be upon us pretty quick. So if you'll just let us know what you find out, Mr. Schmidt, let us Tabraham know that we can get that bench warrant going or do something else.
Sure. Will do.
All right, sir, Ms. Tabraham, is that all we have on the?
I believe so.
All right, so no more extraditions or anything else at the jail?
Yes, sir.
Okay. All right. Then I guess that concludes our business. We adjourn for the day.
Thank you.
Thank you. Thank you, Mr. Hartwell.